Ladies and gentlemen, welcome back for the third session of the PatentSight Summit 2020. After the previous presentations from France Privé on the use of PatentSight for analytics in transactions and licensing, and Electrolux showcasing to us how PatentSight supports the transition of IP departments to become internal business partners, we'll yet get another rather exciting perspective today from an outside counsel point of view. My name is Marco Richter. I'm the Managing Director of PatentSight. Before we get started with the presentation, let me cover a couple of housekeeping points. We've scheduled around 5 minutes of Q&A towards the end of the session. Please feel free to ask any kind of questions you have for the moderator or the presenter through the questions tab on the GoToWebinar panel. Lastly, at the end of the webinar, you'll be redirected to a feedback questionnaire. We would appreciate it greatly if you spend 2 minutes to submit this survey. I'm very glad to have CG Moore with us today. CG is a partner at McBee, Moore & Vanik, a IP boutique patent law firm in the greater Washington, D.C. area, representing the a lot of US, but also many international clients, and among them many PatentSight customers as well in the fields of biotechnology, chemistry, medical technology, and pharmaceuticals. As a registered patent attorney, Dr. Moore concentrates his practice in the fields of biotechnology and chemistry, with a particular emphasis on molecular and cellular biology, small molecule chemistry, medical devices, agricultural chemistry, and food additives. In addition to the preparation and prosecution of patent applications, CG also has broad experience with ex parte re-examination and inter partes review proceedings, appeals to the PTAB, managing patent portfolios, drafting patent licenses and opinions, performing due diligence in connection with public financing and acquisition, and the support of litigation involving patents and trademarks. CG will be talking today about the usage of PatentSight to evaluate an M&A target from an outside counsel's perspective. During M&A activity, evaluating the relative strengths and weaknesses of parties' patent portfolios is a time-consuming but crucial exercise. A company's IP portfolio can be a key value differentiator, either supporting or undermining the rationale for an M&A discussion. Learn from outside counsel how PatentSight facilitated a due diligence analysis and provided clear answers to questions from management. And with that, CG, I'm really glad to hand it over to you, and very much looking forward to what you have to show and share with us today. Thank you.
Great. Thank you, Marco, and thank you all for joining today. I'm really honored to be asked to discuss this topic. It's a very interesting one for us because we've recently been using PatentSight, and we were excited to learn of it from some of our contacts, and then we had the opportunity to use it in an M&A situation, and we found it was quite useful because it helped us translate some rather complicated and multifaceted topics in ways that facilitated the discussions with our clients and with our clients' management as well. So I'm just going to talk then briefly, let me rearrange my screen here, about us and how we use this. So as Marco mentioned, we're a boutique patent law firm, and we focus on mostly biochemistry and biotechnology. And we are very interested in taking advantage of improvements in digital technology. And we're completely paperless, and we've all been working remotely since 2016 ourselves. And recently, we've been using PatentSight to perform analyses for clients in different situations, including M&A, IP due diligences. So we do the kinds of things that you might expect a patent law firm to do. So a lot of patent prosecution, application drafting, opinion work, and IP due diligence as well. And that's what I'll be referencing today. So we found that PatentSight lets us distill complex sets of data, complex amounts of information into information-dense summaries of that information. And that really helped us help the stakeholders on the other side. So for instance, managers, in-house IP counsel, etc., help them understand our conclusions without getting lost in the details of paragraphs upon paragraphs of text. And so this is generally where we are when we're looking at starting an M&A project that has a lot of IP involved. So our client generally has at least a basic understanding of that IP that is involved and what they want to do with it, but they need to know a lot more about it before they can commit to moving forward. And so that's where we come into the picture. So they're generally hoping that this IP will be really useful for them. They're hoping it's going to protect their activities, whatever they want to do, so that it will maybe keep others from intruding on that space, or maybe it'll provide a bridge for a strategic alliance. And our job then is to check their hopes and dreams against reality, at least as far as we can see it. So we have to look into questions of infringement, liability, the scope of the IP that they're looking at acquiring. And at this point, we really have to listen to what the client is asking, what they want, what they need, what their business goals are, and then try to match that against everything else, against the reality. And hopefully we can find an overlap between them and make valid, useful recommendations. So nobody wants to do a bad deal, and yet bad deals happen for all sorts of reasons. Good deals also happen. When IP provides most of the value of the companies, so like in the slides that I'm going to show you, this was the case, then knowing the strengths and the weaknesses of that IP is really crucial. So for instance, the stakeholders might want to know how much their IP is worth. Is their IP worth more than the other side's? Because that could go into negotiation. Is every part of my IP valuable, or is every part of the other side's IP valuable, or is it only part of it? And if only part of it, where is that value? What will we really get from this deal? And then what do we even mean by the term value? So I'm going to assume that everyone on the call is familiar with the PatentSight metrics, such as market coverage and technology relevance, competitive impact, and patent asset index. However, explaining those concepts and understanding those concepts in a way that you can get that message across to stakeholders is a very important part of demonstrating that the results derived from PatentSight are meaningful. So the process of due diligence generally considers a lot of information from a lot of different sources. I'm not trying to say that PatentSight is a substitute for any of these, or that it can do everything that you need in an M&A type of process. An M&A activity takes, when we're dealing with intellectual property, there are a lot of different sources of information that we have to consider. For instance, priority dates, claim language, the prosecution histories, the license terms. All of these are very, very important things that all have to be considered. And looking at things in PatentSight is just another helpful way to interpret some of these other things. So we're drawing conclusions from many different sources. And now PatentSight is one of them. So at the end of the process, hopefully we'll have come up with a nice, clean set of understandable conclusions that we can present. That's the goal anyway, but it starts out with a lot of disparate sources of information that have to be put together and organized. And so with PatentSight, we found that that has helped us a fair bit. It helps support that process for us. So in an M&A context, we found that it helped us and the stakeholders have better conversations about the IP. So it's an iterative process. We might come up with a conclusion, an interim conclusion that we take back to the client, and then they'll ask further questions or redirect, and we can take the analysis further along in PatentSight. Or check that also against other situations, other sources of information, like the licenses, like the prosecution history. With PatentSight, we found it useful because we can take a large volume of information, put it all together in one place, and run analyses on all of it, and look at it from different angles, look at it in different ways, ask different questions, present those answers to the clients, get different questions back, and start the process over again, and eventually come up with a full set of answers. We can also test our assumptions using PatentSight. So we found it's useful to judge the strengths and weaknesses and maybe find hidden weaknesses or strengths in the IP. And like I mentioned, to test the conclusions that we've generated from other sources. And again, we're not only using PatentSight. It's not a substitute for doing your homework and doing a due diligence, a full due diligence. We found it useful to be an additional component of an IP due diligence. So, for example, if the conclusions that you generate from reviewing the licenses, the prosecution history, and everything else match what you're seeing from an analysis in PatentSight, well, that's good. At least that fits. But if you find a mismatch, then that might suggest that you may want to look into reasons why. So for instance, if your expectation of value is high, but PatentSight is showing that the value is not so high, then why might that be? And just the same, if you think the value is low, but PatentSight is telling you the value is high, again, why might that be? Is it just that IP is valuable, but it's not maybe useful for the business? That could be. Again, this is just another way of looking at things, and helpful for fitting the different pieces of an M&A activity together. So where we start, and this is where we start head, because what I'm about to show you is what we did, anonymized and changed around a bit to make things anonymous. But we built a list of patents for all of the parties using the PatentSight tools. And we created company-specific tags for each so we could keep them separate in the system. And we used other databases as well. For instance, the LexisNexis Total Patent 1 database was useful for us to find other sources of information. And we found that the importing patents to tag function and the custom fields functions were incredibly useful here. So the custom fields let us add further attributes to help track things, and then just importing everything into tags so that we could follow it and do our analyses and keep the different companies' data separate in ways that could let us do further analyses. Very, very useful. But this slide shows you how we started with the project I'm discussing today. So after putting everything into PatentSight, the first thing we looked at was which portfolio was larger and how did the sizes compare to one another. So we looked at the number of families over time on the left and the total number of patents on the right, and we could see that both parties were growing, and we already had a sense of that, but it was useful just to see the relative level of growth between each. And you can see that company A in the orange here has more than twice as many families on the left and more than 4 times as many patents as company B. But we wanted to know about the overall value because that's really the question, one of the questions that we're trying to answer here. And this was where it started to get a bit interesting, and we found our first surprise. So we looked at external patent asset index and external competitive impact for both of these. And these are from citations to this IP from later patents. So it's like a popularity score. We already had a good sense of the value of company A in the orange. We were familiar with them, but the increasing value of B was surprising. So the patent asset index score for B has been increasing quickly, although not quite as quickly as for A. But this was a bit of a surprise. The average quality shown by the competitive impact score was higher. And that was surprising until we remembered that a patent asset index is the competitive impact times the number of families. So it's A's larger size that is influencing this on the left. But this is good to know that the average quality of the portfolio in B is rather high, or at least relatively high compared to A. So that was good. Next, we wanted to see how the different technologies overlapped. And we wanted to know if one party might be adding technology that the other didn't have. So these are the top 10 IPC classifications for these portfolios. And you can see that they overlap significantly. So we did this because we wanted to know if the different sides might have gaps in technology that the other might be able to fill. And we didn't find that, but that's okay. But it was useful to know this and be able to discuss this. So now, if you think back to the last 2 slides and this one, we've learned pretty quickly that about the relative size of each portfolio, the change in size over time, and the change in quality, and also that the portfolios are mostly in the same technology space. So we wanted to get a look now at the different pieces of company B's portfolio. So the different chunks of assets in there. We started by looking at them together here on the left. And so when you consider them together, we could see that patent filings had increased significantly as of 2016, shown down here. So the number just escalated very, very quickly. But if you divide up the results now between A and B, as shown on the right, you can see that most of those filings are from company A. And you'll note on this figure, the different colors, those are for different parts of company B. And we found that very useful for us to do it that way, because company B had different clusters of assets. Some was co-owned, some was owned by company B itself, some was licensed in, but this let us track each separate contribution to that portfolio. And we found that very, very useful. And so interestingly, when you look at this graph that way, you know when those different assets came in and how old they are. So you can continue to track that. So we wanted to know then what parts of these portfolios are contributing to the different quality metrics. So here we're showing the contribution to the PAI score and when were these applications filed that are now contributing to the score. So most of the value in these portfolios comes from filings made after 2013. So the portfolios are fairly young. And most of the value is coming from company A, as shown here on the right. And most of these filings are from 2016 and later. But one interesting thing, and this was interesting to us here, is that you can see that a lot of company B's value in their portfolio comes from one particular component. And notice company B has all of these other components, but it's this one up here that is showing up as being highly valuable. The rest is maybe not as obviously valuable, and its age is spread out. Some of it is older. But these two graphs are showing us that there is value in both of these, and a lot of that value is fairly young. This slide simply summarizes a lot of the findings that I've shown in the previous slides. So we can see that the relative portfolio sizes, so the total patents and the total families, and we can see the contributions by different parts of company B to those different numbers. We can also see the relative ranking by patent asset index here on the top bar of company B's different parts. So again, we can see this part of company B's assets were the most valuable according to the patent asset index score. We can also see that it was only 12 families that contributed to that score, whereas this next most valuable one with a score of 93, that was 19 families. So it's important, however, to note that not all parts of company B's portfolio were going to be interesting to company A in this instance. So just because something might be valuable doesn't necessarily mean something is going to be useful. So we can point out this high score all we want, but if those families aren't protecting something that is going to be useful to this entity, then that value is not so valuable, frankly. And yet, on the other side, if company B knows that this part is valuable and is using that to emphasize its price in a negotiation, then it's important to understand how the two parties are viewing these different things. Another useful thing for us in looking at the data was to compare the portfolios by deciles. So the top 10% of patents worldwide, they form the 10th decile over here, and the next 10%, the 9th decile, and so on. And most of these patents in these portfolios, they fall into the 9th and 10th, or well, actually they fall in mostly into the 10th deciles. Now, this is only looking at technology relevance, which is based on the number of prior art citations received from the later patents. So it's like a popularity score. How much are these assets getting recognized by others, getting cited by others? And then if we look at just the top 2 deciles, we can see how the different parts of A and B fall in there. And again, this part of entity B's portfolio is strongly represented there in that score. We can also look at this same sort of data looking at the competitive impact score. And this looks very similar to the technology relevance score. So competitive impact, you're probably aware, it combines the effects of technology relevance and market coverage. So if there were a great big difference in market coverage, you might see that here. But again, most of these patents remain in the top 10% worldwide. So it was at this point that we wanted to look a little more clearly at the different elements in B. And to do that, we compared the external patent asset index and external competitive impact against their portfolio sizes. So remember that PAI is influenced by the total number of families. So that is why you see this score for A quite high on the PAI side, and then it drops on the competitive impact side. So you don't have the same impact, or rather the same influence brought in by the number of families. But now we can see that in entity B, this asset here was growing significantly. And if you look just at the competitive impact, it really does look quite valuable. So when we saw this, I mean, that pointed out to us that maybe this could be something that company A would want to use. However, it turns out that what company A really wanted was something that gets lost down here. And this was not quite as interesting to company A. And when we take just the top 2% of PAI and competitive impact, because we could separate by deciles, for instance, or any percentile that we wanted. Here we took the top 2%. And we could see that the increase in this part of company B's portfolio really was mostly just this. Some of this entity as well, but mostly this part of company B. So with this information, we were then able to go back to our clients and have a discussion and get further questions, which we were able to then use to subdivide these data, these results, even more finely and generate another round of information that's really beyond the scope of what we're talking about today. But we learned from a very few set of slides, really, how the parties' portfolios have been growing, the number of patents, number of families, the different quality metrics. We know how the different parts of B how the different parts are contributing to the size and the quality, or not contributing. And then that helped us discuss things with our clients, and they were then able to have better discussions internally. So again, just because something is showing up as valuable, maybe it's useful or maybe it's not, but at least knowing these kinds of things, you can have that kind of a discussion. And knowing this, then we were able to bring that into our conclusions from other parts of a due diligence and confirm whether what we were seeing there was real or not. And with that, I'd like to open the floor to any questions.
Thank you very much, CJ. And yes, there were indeed quite a few questions. I'd like to take one here to get us started with a couple of minutes of follow-up questions. The use of the patent asset index in this particular analysis, was it something that the client requested from you, or was it something that you proposed? And how was it received by the client?
It was one of several things that we proposed. And like I showed, we had the competitive impact and the other scores as well. But I suspect that the questioner may be asking if that was the overall analysis that we proposed. And actually, this client, they did ask us to do that. They were familiar with PatentSight and wanted us to run this analysis for them. So they did know about the PatentSight metrics, and they did feel comfortable with them.
Okay.
But that is a good point. If somebody has not faced this before and is unfamiliar with how PatentSight ranks different IP, then that would be an important thing to understand and an important thing to explain.
Mm-hmm. And just out of my own curiosity, how did this case end? Was the company ultimately acquired or not? And did the IP analysis play a role in that?
It played a role, and the company was not acquired.
Okay, so it wasn't convincing what IP showed there.
Right.
How would you have? Yeah, sorry.
I'm sorry. I would just add that IP was the major asset for both of these companies.
I see. Okay. So how would you have done such an analysis from an IP angle, like, let's say, 5 years ago when you were not a PatentSight customer yet?
Yeah, well, we would have had to do a lot more digging into the different parts of the portfolio to then figure out separately on our own how these things were contributing to value. So for example, in the thing that the client was very, very interested in, it was valuable to them. It was useful to them. However, there were certain things that came through in the license terms, in the prosecution history, and frankly, the age of those assets that cut against value. And those were, not all of those things are things that you can see in PatentSight, but some of them definitely are. Value generally, so how much is that getting recognized by others by being cited? And how old is it? That was very, very easy to see. And those metrics fit with the kinds of things that we saw separately then from looking at the license terms and other things in the prosecution history.
And as a last question, what would you say to IP counsels? It could be in-house or external ones that are more hesitant when it comes to using advanced patent analytics. And I mean, going beyond filing statistics or claim-by-claim analysis and really get a bird's eye view. What would you suggest to them, to overcome that barrier that some of them face, and what kind of additional insights would open up to them if they'd be embracing modern technologies here like PatentSight analytics more actively?
Well, I mean, that kind of hurts us really to have more people using this, frankly, because we see it as an advantage for us. So if they really are set in their ways to not use things like that, then that's that's not my job to convince them. Just as it's not my job to convince somebody to use the internet. If they want to rely on the mail, that's perfect.
Right.
But like I said, it's another view into this large set of data, a lot of different things influencing the decision, influencing the perception of value, the perception of risk. And this can save a lot of time and effort and point out where you're probably correct in your conclusions, or where you may be incorrect, or where you've missed something, where maybe if there's a mismatch, and that actually is fairly interesting, if there is a mismatch, because we saw that here with this project. We found some things that looked interesting, but then when raised with the client, they said, no, that's not what we want. Whereas other things that did not look interesting, and they said, that is what we want. Well, that generated a discussion, and that caused us to focus more thoroughly on that. So it helped redirect resources rather than using a blanket approach on everything and doing that same scorched earth analysis for everything, which would have taken a lot more effort, a lot more time. This let us use the resources a bit more wisely and answer certain questions much more thoroughly, and so get to a satisfactory conclusion earlier.
Yeah, thank you, CG. I think that while you may convince some of your competitors out there to look into more advanced analytics, I think you'll still maintain quite an advantage being an early adopter of these modern techniques. So I wouldn't be worried at this point just yet. And I mean, it keeps us all on the edge of innovation, right? Like we need to improve continuously.
Oh, yeah.
Thank you for joining us today, for sharing your insights about PatentSight with the PatentSight community. Hope to continue the really extraordinary relationship we have with you and your firm. And I would like to thank the audience for joining us today. And I'd like to also mention that we'll see each other at the same time next week for 2 more presentations of the PatentSight Summit 2020 from Thomas Spernert from Heraeus and from Professor Bowman Hayden. Thank you all very much. And CG, I'll leave the last words to you.
Yes, thank you very much, Marco, and hope I can see you in Bonn sometime soon.
Absolutely. That would be great. Thank you.